Good afternoon, everyone, and thank you all for joining us for today's presentation. My name is Marissa, an attorney with Legal Aid of North Carolina's Helpline. Today, we have Brian Hogan presenting for us. If you're unfamiliar with the format of this event, first, Brian is going to review a PowerPoint presentation. At the end of the presentation, we will have a question and answer session. If at any point during the presentation you have questions, you can put them in the Q&A box on Zoom or the comments section on Facebook. We'll review all questions put in the chat boxes during the Q&A session at the end. Please remember that this is a public forum and Legal Aid is not representing you at this time. Brian will go over this in more detail, but please remember to keep your questions as general as possible, as we cannot provide any legal advice specific to your individual situation. The session will end when there are no more questions. With that, I'm going to pass it over to Brian to get us started.
Hey everybody, welcome. So my name is Brian Hogan. I'm a supervising attorney in the Greensboro office of Legal Aid of North Carolina. And I'm going to be talking to you today about Social Security disability law. In particular, today we're going to be focusing on the medical standard for disability for the SSDI, that's the Social Security Disability Insurance Program, and the SSI, the Supplemental Security Income Program. Both programs have the same definition of disability. This is part of a monthly series that we do on Social Security disability law, where we sometimes focus on different issues. But again, today we're focusing on what the medical standard for disability is for folks that are applying for these benefits for the first time. So in general, though, what you should know about Social Security disability insurance and SSI is that these are two programs administered by the Social Security Administration that provide public benefits to individuals that meet certain non-medical criteria as well as medical criteria. And if you do so, then you're eligible for a monthly benefit amount. We're not going to go over the distinctions, the non-medical distinctions between the SSDI and SSI program today. They are in some ways very different programs in terms of how they're administered and the non-medical requirements for each program. Again, rather what we're focusing on today is the similarity between the two programs, and that is the definition of disability, which in some ways is the most important part when you're trying to win your initial application or your subsequent appeals before the agency, is to show the adjudicator or the judge that you are in fact disabled under Social Security's rules. So what is that definition of disability? I'm going to read the actual definition from what's called the Code of Federal Regulations. And these regulations define disability as the inability to do any substantial gainful activity by reason of any medically determinable physical or mental impairment, which can be expected to result in death or which has lasted or can be expected to last for a continuous period of not less than 12 months. That's a short definition of disability, but it's actually very complex. And each of those terms means something. They're a term of art, so to speak, for the disability program. So we're going to go in detail through what's called the 5-step sequential evaluation process that really fleshes out that definition. And this 5-step evaluation process is the framework that Social Security's adjudicators or judges use when they're determining whether or not a particular claimant, that is a person applying for benefits, meets the definition of disability. So the first question that an adjudicator is going to ask is the claimant engaging in substantial gainful activity? That's step one of the analysis. Is the claimant engaging in substantial gainful activity? So what does that mean? Essentially, Social Security is asking, is the claimant currently working? And if so, are they working above a certain threshold amount? So if you are not working or not engaging in substantial gainful activity, then you can go on to the next stage of adjudication, which would be step 2. But just to give you a sense, in 2025, substantial gainful activity, the threshold is $1,620 a month. So if somebody is working, but they're making below $1,620 per month, that's gross before taxes are taken out, then they would get past step 1. But most of the time, folks are applying for disability benefits from Social Security because they're not able to work at all. But usually this is a non-issue for most people. And so most people will get past step 1 of the analysis fairly easily. So what is step 2? So if you get past step 1, you go to step 2. Step two, the agency is going to be asking whether or not the claimant has a severe impairment or combination of impairments that meets the duration requirement. That is, does the claimant have a severe medically determinable impairment? So what does that mean? Do you have diagnoses from a medical source, like an MD or a physician's assistant or a nurse practitioner? And does that condition, that diagnosis, cause you to have symptoms that cause more than minimal limitations in your ability to do work? And do those limitations and symptoms, have they lasted for more than 12 months, or are they expected to last more than 12 months? So there's a couple components here, just to repeat that. One is that you have to actually have medical impairments diagnosed by an acceptable medical source. So, for instance, that could be a psychologist, a PhD in psychology, or a medical doctor, an MD, or a physician's assistant, a PA, or a nurse practitioner, MP. And do those conditions that you have, either by themselves or in combination, do they cause more than a minimal limitation in your ability to do work activities? And does that, do those limitations, do those symptoms, those impairments last for more than 12 months, or are they expected to last for more than 12 months? And this is what's called a de minimis screening step, a screening device. It's meant to screen out applications that don't meet a minimum threshold. And most folks that are applying for disability clearly meet this minimum threshold. And so they move on to step 3 of the analysis. And we'll talk about that in more detail in the next slide. But I want to just go over briefly what that step is. And that is whether or not that claimant meets or equals one of the listings of impairments. And this is a set of criteria that Social Security has developed over the years, where if you meet the exact criteria, then you're automatically disabled without looking at other factors. That's step 3 of the analysis. After step 3, in between step 3 and 4, the adjudicator or judge is doing a step that we call the residual functional capacity assessment. They're trying to assess what is the most that somebody can do given the impairments and limitations that they have. And they come up with something called the RFC. After the adjudicator comes up with that RFC, they will then ask at step 4, given that RFC, can that claimant have the ability to do their past relevant work? And if the individual can still do their past relevant work, which we'll define in a moment, then they are not disabled. But if they cannot do their past relevant work, then you move on to step 5 of the analysis. And this is called, well, it's called several different things, but essentially the point is that the adjudicator is going to be trying to assess whether or not there are any other jobs in the national economy that exist in significant numbers that claimant can do despite their impairments. So literally, you have to prove to the administrative law judge or the adjudicator in your case that there are no jobs in the national economy that you can do. And that's step 5 of the analysis. We'll dive into steps 3, 4, and 5 in a little bit more detail on the next slides. So again, if you get past step 2, you go to step 3, you can actually win or lose your application or appeal at step 3 or at step 3. So you can't lose, but you can win at step 3. So strike that. And at step 3, the question is whether or not the claimant or applicant meets the listing of impairments. And you can see the listings on SSA's website. So here's a link to the listing of impairments. It used to be called the Blue Book because literally it was a publication, a paper publication that had a blue cover on it. And in that Blue Book, there's just 14 different body systems that are listed. And under those body systems, Social Security has developed specific medical criteria where if you meet those exact criteria, then you're automatically found to be disabled without consideration of other factors. So here's an example of what one of the listings looks like. This is listing 1.15, disorders of the skeletal spine resulting in a compromise of a nerve root. And so if you meet these criteria, so for instance, say you have a neuroanatomic radicular distribution of one or more of the following symptoms consistent with compromise of the affected nerve root, such as pain, paresthesia, or muscle fatigue, and you have radicular distribution of neurological signs present during physical examination, as you see below, and you have findings on imaging of compromise of a nerve root, and you have that level of functional impairment that's listed in section D here, then you would automatically meet and or medically equal the listing for disorders of the skeletal spine resulting in compromise of a nerve root. This is a fact-intensive examination. The primary evidence that's used by the adjudicators to determine whether or not you meet a listing are your medical records. So Social Security, during the various stages of your application and appeal, are going to collect your medical records from your medical sources. It would behoove you to also help them get those medical records by making sure that when you apply or when you do your appeals, that you list all your medical sources that you see on a regular basis. In fact, you have an obligation to do so. And also to follow up with Social Security to make sure that they're getting those records, or if you're able to get those records for them, to submit them to Social Security. Because Social Security is going to be examining and reviewing those records to determine whether or not the laboratory findings and the signs and symptoms in those records are consistent with one of their listings. Now, if you don't meet a listing, it's fine. You just go on to step 4. But again, between steps 3 and 4 of the analysis, the adjudicator is going to determine your residual functional capacity, or RFC. And that's an assessment of what of your abilities to do sustained work-related physical and mental activities in a work setting on a regular and continuous basis, meaning 8 hours a day for 5 days a week, or an equivalent work schedule. And RFC is not the least that somebody can do, despite their limitations, but it's actually the most that they can do. And so Social Security looks at various components in developing your RFC. The first is they look at exertional limitations. And these exertional limitations address your limitations in physical strength, and they rate your ability to do activities in the following categories: your ability to sit, your ability to stand, your ability to walk, your ability to lift, your ability to carry, push, and pull. So those are the exertional limitations that Social Security will assess when trying to figure out what your residual functional capacity is. Social Security is also going to look at non-exertional limitations in deciding what your RFC is. And these are limitations that are essentially not strength limitations. So your ability to manipulate objects, so using your upper extremities to reach, handle, and finger, your ability to perform postural movements such as stooping and climbing, your visual limitations, if any, such as your ability to see with fair acuity or field of vision. You're going to assess whether or not you have any communicative limitations related to, say, hearing or speaking. Do you have any environmental limitations, such as an inability to be around noises or fumes or hazards? And importantly, for many cases, they're going to assess what, if any, mental symptoms and limitations that you do have. And they're going to be looking at several domains, such as your ability to understand and remember instructions, respond to coworkers, colleagues, and supervisors appropriately, to maintain attention, concentration, and persistence and pace, to adapt to work settings, etc. But such mental limitations are incorporated into your RFC by the adjudicator. And after the adjudicator comes up with that RFC, and that's again a set of limitations that you can have. What is the most that you can do despite these medical impairments? They're going to look at your past relevant work, and they're going to ask the question, can this individual with those functional limitations do their past relevant work? So what is past relevant work? Well, under the current regulations, that's any work that you've done in the past 5 years, either from the date of the hearing or from something called the date last insured for Social Security disability insurance cases. And I'm not going to go into detail about what a date last insured is for this presentation, but essentially Social Security is going to look back 5 years. And any jobs that you've done in the past 5 years that you've done long enough to learn how to do it for more than 30 days, and that work was substantial and gainful, they will categorize as being past relevant work, and you have to prove that, given your limitation, you can't do that past relevant work. It's your burden to prove that. And it's really important for this assessment that when Social Security sends you work history reports when you apply or during the pendency of your appeal, that you fill out those work history reports with as much detail and accuracy as you can. The more details about how your past work was performed, the more helpful it will be for you to prove that you can't do that past work. And I'm talking about very fine details. So when Social Security asks you, for instance, how much you had to lift and carry in that job, make sure that you explain to them the maximum amount you actually had to lift in that job. And that will become helpful when you have to prove that you can't do that any longer, given your functional limitations. Here's an example of what one of these work history reports look like. So Social Security, the appeals and application process is heavily form intensive. Social Security is going to be sending you lots of forms to fill out, and you have to make sure that you get those forms back to them. And if you can't fill them out on your own for whatever reason, make sure that you have a family member, friend, or hopefully an attorney help you with these forms so they can be filled out completely accurately and efficiently so they get back to the agency so they can make a determination on your case um, in a timely manner. Of course, everything with Social Security takes a long time. There's a significant backlog of cases at the various levels of appeal for Social Security. And we're talking about a process that could take 1, 2, 3, sometimes more than that, depending on how far you have to appeal your case. So this is a time-intensive process, but to make sure that it goes as fast as it possibly can, getting these forms back to Social Security in a timely manner is going to be really important for you. All right, so let's get to step 5. So let's say you weren't found disabled at step 3, so you went on to step 4, and the adjudicator does find that you can't do your past relevant work. Again, that's any work that you've done in the past 5 years that was substantial and gainful. You then move to step 5. This is where you can win or lose your case. And so at step 5, what the agency is looking for is whether or not you can perform other work that exists in significant numbers in the regional or national economy, considering your residual functional capacity, your RFC, and vocational factors such as your age, education, literacy, and work history. And by looking at a combination of these factors, Social Security can make a determination about whether or not jobs exist in the national economy. Social Security has created an administrative framework to decide this for people that are 50 or above, age 50 or above, and that's called the Medical Vocational Guidelines. You'll see it referred to as the grids when you're talking to a Social Security attorney or looking up information online. And this is a framework that makes it easier for Social Security to approve cases for folks that have exertional limitations when they're 50 or above. But it's pretty difficult to win your case when you're below the age of 50 because you literally have to show that there are no jobs in the national economy that you can do. And there's a slight burden shift, though, at step 5. The agency has to actually prove the existence of these other jobs. And they do that usually, at least at the hearing level, by relying on somebody called a vocational witness or a vocational expert to help the adjudicator determine whether or not other jobs exist that you may be able to do, given limitations that the adjudicator believes that you have. But this is an important step. Again, like step 3, you can win your case here. And unlike step 3, you can actually lose your case here as well. So that is the 5-step evaluation process for determining disability for folks that are initially applying or going through the appeals process to get on SSDI or SSI. Again, there is a lot more to the Social Security disability programs administered by Social Security. So for the Social Security Disability Insurance Program, there is non-medical requirements regarding whether or not the individual is insured for benefits, whether or not you have a significant number of work credits that you've performed over your lifetime and within the last few years before becoming disabled. And then for the SSI program, which is not an insurance program, it's what's called a means tested program. There's a bunch of non-medical requirements where Social Security looks at your income and your resources to determine if you also qualify. But both programs, again, have the same exact definition of disability. And although that definition of disability is relatively compact, it's much more complicated than that. And as we've shown, essentially Social Security is going to use a 5-step evaluation process to determine whether or not you meet that definition. So I'm happy to take questions right now about the medical criteria for disability for Social Security disability benefits and SSI. Again, I want to remind you, though, that this is a public forum. Any information you share is not confidential, and so I would ask that you refrain from asking specific detailed legal advice about your situation. If you do have questions about your situation, I would encourage you to call the Legal Aid helpline at 1-866-219-5262. That's 1-866-219-LANC. We're open from 8:30 a.m. to 1:30 p.m. Monday through Friday. and 5:30 p.m. to 8:30 p.m. Monday and Thursday. I hope that is still accurate information, but if it's way to check is by going to our website at legalaidnc.org, where we'll have the most updated information about the times that our helpline is open and how to apply for our services. So, Marissa, any questions in the chat that I should see?
Yes, we've got just a few questions here. First one, someone is asking if people are allowed to work at all after they've been approved for disability, especially
Yeah.
with the current economic structure right now. Can people
Yes.
work at all?
This is such a complicated question. So Social Security, especially in the Social Security Disability Insurance Program, SSDI, they do have what's called work incentives. And these are incentives that are supposed to encourage people to return back to the workforce through a trial work period where you could test your ability to work for up to 9 non-consecutive months and keep your benefits in the Social Security Disability Insurance Program. After that trial work period runs, there's something called an extended period of eligibility, where you can continue to test your ability to work. But if you go above a certain threshold amount, that's the substantial gainful activity amount, that you don't get your benefits for that month. After that 36-month period ends, you then, if you work above SGA, you get cut off of benefits. But there's a way to get back on benefits called expedited reinstatement. If you are still disabled, you're no longer engaging in work activity. It's a very, very complicated set of rules and regulations regarding trial work periods for beneficiaries. Here's what I can tell you. That Social Security, in theory, has people on staff that are supposed to be experts in trial work periods and work incentives. And you should contact Social Security if you are getting benefits and you're contemplating going back to work. In addition, if you do go back to work while getting benefits, it's really important that you report on a monthly basis any of the earnings that you receive. Here's the thing that I see a lot as an attorney doing Social Security law is I think these work incentive rules, in theory, are helpful and fantastic to encourage Social Security beneficiaries to test their ability to go back to work when they're recovering from some of their medical impairments. What I do see, though, quite often is I see people getting into problems with overpayments when Social Security either does not process the earnings that you've reported to them, or they don't catch these earnings until a much later time. And then individuals get hit with these large overpayments, tens of thousands of dollars that Social Security says you need to pay us back. And so I'm not saying that to discourage anybody from attempting to go back to work, but I am saying is to consult with Social Security staff that have detailed knowledge about work incentives and getting Social Security benefits before you attempt to go back to work, and to also make sure that you report your work activity when you are going back to work. Now, the rules for SSI are slightly different. So for SSI, because it's a means tested program, if you do return back to work, for every $2 that you earn, they would reduce your SSI by $1. It's a 2-for-1 offset for earned income after essentially an $85 disregard. So again, for SSI, like for SSDI, it's possible to attempt to go back to work and still get some of your benefits. But again, it's going to be really important that you report that work activity to Social Security on a regular monthly basis, so you don't get hit with an overpayment of benefits at a later date that you would then have to be liable for and pay back Social Security. So reporting your earnings is always key for testing your ability to go back to work. But for the different programs, Social Security, Disability Insurance, and SSI, there are different work incentives. They're slightly different in terms of how they're administered because of one program being an insurance program and the other being a means tested program. So the answer is, that's a long way of saying the answer is yes, you can test your ability to go back to work, but it's complicated. And to seek out legal advice or advice directly from Social Security before you do that. That way you can try to minimize the risk of getting an overpayment. Even if you try to minimize the risk of getting an overpayment, for a lot of people, they still get hit with an overpayment because of processing errors and other issues with dealing with these complex work incentives rules in a large bureaucracy. So just be aware of that. Any other questions?
Yes. is this five-step process the same for someone who's applying for disability when the disability is mental illness related?
Yes. So for initial applications, so people applying for the first time, if you're an adult, the five-step process is exactly the same. So step one, are you engaging in work activity? Step two, do you have a medically determinable severe impairment? Step three, do you meet or equal the listings? And there's a set of listings for mental health. Step four, given your residual functional capacity, can you do your past relevant work? Step five, given that RFC in your age, education, past work history, and literacy levels, can you do any other work in the national economy? The exact same if it's physical or mental. So the answer is yes. There are different rules though for children. So there's a child SSI program for folks that are below the age of 18. That program has a different evaluation process. And it's not about the child's ability to work. It's about whether or not the child has functional impairments compared to other children of their same developmental or stage or age. So that's another SSI disability program, but for children with a different standard. And then for folks that are currently getting SSI or SSDI, periodically Social Security is going to review your case to see if you still meet the definition of disability. And that's a slightly different evaluation process. It's a 7 or 8-step evaluation process that's similar, but there are some slight nuances to the initial evaluation standard. Essentially, what Social Security is looking at for continuing disability reviews is whether or not there's been any medical improvement related to your ability to work since you were last found disabled under the program. The short answer is yes. If your impairments are mental health solely, or a combination of mental health and physical, or physical only, the evaluation process is pretty much the same through what I've described, the 5-step process.
Okay, and next question. We'll see if you can answer this one. Can someone retroactively apply for temporary disability?
Okay. Now, there's no such thing as temporary disability in the Social Security program. It's neither a temporary or a permanent disability program. It's a disability program where you have a set of impairments that is expected to last for more than 12 months, or has lasted more than 12 months, or can be expected to result in death for a terminal illness. But what you may be asking is whether or not you can get a closed period of disability where you apply when you apply, say you're disabled, but I don't know, 2 years later, when you're still going through the appeals process, you've actually medically improved. So could you have a finding of a closed period of disability where you say you're just disabled for 2 years, for instance? And the answer is yes. As long as you meet the 12-month duration requirement and the other requirements that we talked about medically and also non-medically, then you can have a closed period of disability where you get a disability period for a definite amount of time, but not ongoing. So that happens occasionally as well. Sometimes we see this for folks that are undergoing treatment for cancer, where for a period of, say, a year and a half or 2 years, based on the treatment and the symptoms and limitations that somebody is having, they clearly can't engage in full-time work activity. But then they go into remission, and maybe they can go back to work on a full-time basis. Well, those individuals would still be eligible for a closed period of disability if they meet the medical and non-medical requirements.
Perfect. And then the last question I see here, someone's asking, can someone still get disability if they do not have a running work history? I think is the question.
Yes. So that's a good question. So that there is a difference between the Social Security Disability Insurance Program and the SSI program. The Disability Insurance Program is an insurance program, as it suggests, meaning that you have to have a work history where you pay into the program, and you're insured for a certain period of time after you stop paying in. You pay in through your paychecks. So if you're employed, when you get your paycheck and you see that those FICA taxes are taken out, or the Social Security tax, you're paying into the Social Security retirement and disability programs. Let's say you don't have a work history for various reasons. There could be many reasons why you don't have a work history where you're paying to the system. Could you still be eligible for disability? Well, you're probably not going to be eligible for Social Security disability insurance under your own record, but you may be eligible for SSI. That's the disability program that's means tested, assuming that your income and your resources are below certain levels. And for this presentation, we didn't go into any detail about what those levels are, but they are fairly strict, these resource and income levels. But it is possible to get SSI if you meet the definition of disability, you meet those income and resource requirements, and you don't have a work history. Other ways of getting disability benefits through the disability insurance system is that disabled adult children that have a parent wage earner, for instance, that is retired, disabled, or deceased, and the child who's now an adult has been disabled continuously since before the age of 22, excuse me, they may be eligible for benefits under their parents' earnings record. Disabled widows between the ages of 50 and 59 may be disabled under their deceased spouse's earnings record, even if they didn't work. So there are other nuances here, but in general, you should know that if you don't have a work history, you're not going to qualify for disability insurance benefits under your own record. But you may qualify for SSI if you meet those non-medical SSI income and resource rules.
Perfect. Well, I am not seeing any other questions, so I'm going to go ahead and say it. Thank you all for joining us, with a special thanks to Brian for presenting and for answering all those questions. If you would like to review anything we talked about today, we have posted a recording of today's event to our Facebook. It will be immediately available. You can access this recording with or without a Facebook account at www.facebook.com/legalaidnc. If you would like to register for one of our other Listen and Learn presentations, such as on child custody, food stamps, tenant rights, you can do so on our website at legalaidnc.org/clinics. Thank you all so much, and I hope everyone has a great rest of their afternoon.